Next case is 527-084, matter of Jacobson versus Blaise.
We're taking a break. Yeah, after this. What? Are we super hot? Are you hot?
We'll hear this case, and then we're going to take a brief recess.
Good afternoon. I would like to reserve 2 minutes for rebuttal.
Okay?
Thank you. May it please the court, my name is Barry Jacobson, and I represent Matthew Jacobson, the petitioner in this matter. Some 22 months ago, respondents asked this court for a do-over to correct a, quote, mistake in their process that led to this court's annulment of the respondent's previous decision. We are back here today because what we believe respondents have shown that this mistake was not a mistake at all, but the result of a lack of understanding of both the enabling law, their own promulgated procedural regulations, and a total disregard for accepted legal norms and principles without common sense. Petitioner has repeatedly described the hearing below as nothing more than a totalitarian state show trial. Whether or not this court agrees with such a description, it is clear that respondents believe that an accused in their forum facing consequences that would label and brand him, in the words of the reporting individual herein, a rapist and serial sexually violent and assaultive predator is worth the same due process protections as one accused of a parking violation.
You're making a due process argument.
I'm sorry, Judge?
You're making a due process argument here?
Yes.
Are you making a stigma plus argument? Is that what you're saying? What are you articulating?
What I'm saying is we delineated a number of what we believe to be due process violations in the hearing below. From the arbitrary and unilateral selection at the beginning by the respondents of governing procedural rules from different versions of their code to the end result of ruling presumptively that making any inquiry into any prior inconsistent statements or behavior indicating bias or predisposition being irrelevant and excluded, coupled with nonsensical rulings allowing witnesses to pick and choose what questions they chose to answer, and the failure to sequester witnesses during the hearing leading to the clear indication of recent fabrication, respondents created the show trial that we're saying. And we're saying this, Judge, because if you look at the due process arguments that we made below, again, starting from this first decision saying we're going to pick and choose from one set of rules and another set of rules, they then didn't even follow those rules. And how didn't they follow those rules? In a number of ways. The first indication was the rules were quite clear that, in fact, certain statements could not be admitted that could have been admitted in the first hearing, which, of course, was 2 years prior to the new hearing, or a year and a half prior. And basically what they were saying is that the witness statements, which had now to be signed and dated, they went ahead and admitted them over our objection. And they said, wait a minute, this is not a witness statement. It's merely a part of the investigative report, even though they clearly had used it as a witness statement the last time around, and they're titled witness statements. We didn't make up the titles, the respondents did. It's their evidentiary package. But even worse than that is they allow in the statement of the reporting individual, who we call KH, to say her closing statement is an impact statement. The impact statement is clearly prohibited by the enabling law in 2 separate sections, as we cited below. But now respondents say to us, this is not an impact statement. This is a closing statement, even though KH herself calls it an impact statement. But then they say to us, well, even if it is an impact statement, you didn't raise this at the argument below, so therefore it's not preserved. Which is really, in a sense, quite arrogant, in the sense that the record shows that counsel made it quite clear to the respondents that he could not hear the testimony of KH. And basically, they say to him, Respondent Allen says to him, we're not going to make any accommodations for that. That's too bad.
You couldn't hear the closing statement, is that what you're saying?
I'm sorry?
You could not hear the closing statement?
That is correct.
Okay.
And that is why we did not object to it, because we couldn't hear it. And that's also why, as respondents say, why didn't you raise this in your internal appellate argument? Well, we couldn't, because A, we didn't hear it, and by appellants, again, own rules, we're not entitled to a transcript to see it until we end up in the Article 78 proceeding. So basically, they're using their own rules, which this court and every other court has said prior to the Title IX Enough is Enough controversy, that a college must follow its own rules. Clearly here, they are not following their own rules in any event. But it doesn't end there. It goes on with Respondent Allen making other ridiculous rulings. For his example, and again, this is all in the brief and all over petitioner's objection of allowing the witnesses to remain, to listen to each other's testimony, failing to sequester the witnesses. And what happens? KH, in her statement, originally and now a year and a half later, makes the same statement. She reads the written statement. In that statement, she never says the word rape. She never hints at the word rape. And yet, after hearing Respondent Blaise use the word rape in this proceeding, now all of a sudden in her closing statement, impact statement, the petitioner became her rapist. And she goes off on this whole different tangent. The point is, that is why we ask for the sequestration of witnesses, so they should not be able to do that. But he goes further than that. When we make inquiry into statements that were made by Respondent Blaise at the prior hearing, he rules those statements presumptively irrelevant and excluded because they didn't happen at this hearing. Any statements that Respondent Blaise that might have were inconsistent, and they were inconsistent in this hearing, as proven by the fact that in her quote, in the quote witness statement allegedly made by the petitioner, which the petitioner has always denied was in fact his statement, she says the petitioner admitted initiating the sexual conduct. Why? Because to trigger this statute, the person initiating is the one responsible to get affirmative consent. In the previous hearing, she equated initiation with penetration. That was her way of articulating initiation. Well, she couldn't do that here because pretty much the court made it clear that was unacceptable. So now when she's asked, how do you define initiation? You're the one who used the word. You never gave any factual statements that the petitioner said. She can't define it. So basically, by limiting this kind of testimony, he allows the witnesses to avoid anything they said either in the prior hearing. He avoids allowing us to use these prior inconsistent statements to attack them, and further goes on to say that anything that happened outside, such as any showing of predisposition or bias, cannot be used. And how do they get around all of this? By calling Respondent Blaise the complainant, even though she's clearly the prosecutor and the investigator and the college's representative, and as we think we have shown, their advisor, and calling the reporting individual a reporting individual when she's clearly a witness or an investigator, shrouding them in a certain kind of respectability, and then going on to say that even though they're testifying, no witness has to answer any question they don't want to answer. Now, this court is well aware that the only one who might be in that position is a defendant, but voluntarily taking the stand kind of waives that privilege.
You are in your rebuttal time right now, just so you know.
Then I will stop at that
Can
point.
I ask one quick question? I'm sorry.
Sure.
Thank you. just, and I'm gonna ask the same question to both. I have an evidentiary question, and it was raised in both briefs. In the Student Conduct Manual, Section 4, they talk about preponderance of the evidence standard,
Yes, sir.
okay? How do we reconcile that with the substantial evidence standard? How does that work?
I believe I addressed that in my
You
brief,
did.
but I will certainly answer that question. This court would have to find substantial evidence to be the foundation of a preponderance of the evidence. And as we're all aware of the Hogue case, both sides cited it, and the court, of course, is aware of it. The Hogue case basically said that the substantial evidence, even if we don't agree with it, has to be based in reason. It has to be
I got that.
reasonable.
Thank you.
Thank you.
Good afternoon, Allison Levine. Good afternoon, may it please the court, Allison Levine for respondents. I'll start where he left off with your question, Your Honor. So the standard is whether substantial evidence supports the determination that by a preponderance of evidence, petitioner failed to obtain affirmative consent. And what that means in English is that the issue is whether or not a reasonable person could find that it was more likely than not that petitioner engaged in sexual conduct with KH without first obtaining affirmative consent.
That sounds a lot like the preponderance of the evidence standard to me.
Well, it's substantial evidence. It's whether or not a reasonable person could find that the college reasonably found, or that, you know, it's whether or not a rational person could find that it was more likely than not.
So the
That he engaged in.
substantial evidence standard, does it subsume the preponderance standard?
Yes, there's two issues here. The first is the standard of review. So the standard of review is whether there's substantial evidence, but the burden of proof below was the preponderance of
Okay.
evidence. Does that make sense? So it's
Maybe.
so it's
Well, our review, isn't it that our review is whether there was substantial evidence?
exactly your review
So our
is
standard of review is
exactly
whether
your
there's
standard of
substantial
review
evidence.
is whether or not substantial evidence supports the determination, and the college had to find by a preponderance of evidence, which is more likely than not, that he engaged in sexual conduct without first obtaining affirmative consent.
So if we don't find substantial evidence that the college found a preponderance of the evidence, it gets kicked?
Yes.
Is that basically it?
Yes.
Okay.
Well, I would just note, Your Honor, that petitioner did not even address the merits of his claim on substantial evidence just now. And there are several undisputed facts that support the determination. First, KH testified that she woke up in the middle of having sex with petitioner, and then she blacked in and out of consciousness. As petitioner acknowledges, she was heavily intoxicated that night. She was stumbling, she was slurring her words. And given these facts, the board reasonably credited her testimony that she was too incapacitated to have consented. And there's no reason for this court to second guess the board's credibility determinations.
Can you discuss the due process issue about the witnesses being permitted to not answer all the questions that were posed to them?
Yes, to the extent petitioner claims that KH or Blaise was selective in which questionings they wanted to answer, again, that went to their credibility. The board was free to hold that against them. And if the board felt that they were being evasive or non-responsive, they certainly could take that into consideration when assessing their credibility. But even beyond that, as Your Honor wrote in the first Jacobson proceeding, each witness is permitted to participate in the process, as you said, as he or she sees fit. And that means that SUNY cannot compel an individual's attendance, let alone their testimony. And so there was nothing that SUNY could have done here to compel KH or Blaise to testify, except do what they did here, which is to hold her possible evasiveness or her alleged evasiveness against her.
Was there any prejudice by allowing them to be, all the witnesses to be in the room at the same time?
No. Well, first, there's no right to sequestration in an administrative hearing. I've actually never even heard of that. But even beyond that, I don't understand how they could have possibly influenced the other's testimony. Blaise was there to present the findings of her investigation. She testified to what the parties told her, that's it. And then KH merely read her statement and testified to her recollection of the evening. So I don't understand how they possibly could have even tailored their testimonies to one another. And there's no, there's no explanation in his brief how this prejudiced them or how they possibly could have tailored their testimony. In fact, petitioner received all the process to which he was due. The record's clear that he received a fair hearing process that complied not only with the student conduct manual, the enough is enough law, but also due process. I'll briefly touch on his comments regarding the impact statement. That claim is unpreserved because it was never raised at the administrative hearing. To the extent he claims he couldn't hear, that's not supported by the record. On page 287, he says he's having trouble hearing. The hearing officer allows him to move closer, and he can be heard saying on the transcript, fair enough, thanks. And thereafter, he actively engages in questioning and participates in the hearing. To the extent he says he couldn't raise it in his administrative appeal, the code specifically provides the pages 219 that a student is allowed to request supervised access to the tape. So while perhaps he couldn't see the transcript itself, he could have gotten access to the tape and heard her impact statement. But nonetheless, there's nothing in the enough is enough law that says that an individual cannot talk about the aftermath of an incident during the course of the hearing. It does allow a student an opportunity to discuss it during the penalty phase, but it doesn't preclude them from discussing it during the hearing. And again, it went to her credibility. If they felt that she was just, making a mountain out of a molehill, then that was something that he could have attacked.
Counsel, can I go back to the substantial evidence issue again?
Sure, please.
Was the group that was rendering this decision, were they advised as to what preponderance of the evidence means? Did anyone ever tell them what it meant?
I don't believe that I don't know. There's nothing in the record to indicate
Well,
that.
I'm just thinking how, like, a judge,
Yes.
gives instructions as to levels of proof to juries, and did they ever get anything like that?
I don't think that they received instructions.
Okay.
There's nothing in the record to indicate, but they have received, what is in the record is that the board members are trained in these proceedings, and they're trained in being on these juries, and they're selected in particular because of their experience. So they've received training on the issues that they've heard, including sexual assault, and also presumably what standard to apply.
Thank you.
And I would note too, it's not, it's sort of outside the record, but one of the individuals was a law professor. So I would hope that he would know what preponderance of the evidence is. But getting back to substantial evidence, as you said, the board reasonably weighed her testimony, and that's a credibility determination that's not subject to review by this court. I'll briefly, I guess, address his bias claim. He's not really provided any basis for the belief that Blaise unduly influenced the board or that she was biased in any way. It's his burden to show that his burden to show some factual support for his claim of bias, and also to show that the outcome flowed from that bias. He's not done that here. It's not contrary to due process to allow Blaise to reappear at the second hearing. This court clearly said that in Weber. It was not contrary to due process to allow the hearing officer to appear at the second hearing, or the director of student conduct. So his claim of bias simply must fail. Regarding his claim that Blaise somehow influenced KH to suddenly use the word rape, it's simply belied by the record. Blaise does use the word rape, but under the student conduct code, rape is defined as sex without affirmative consent. And so she's merely stating the definition of rape under the Student Conduct Code when she's mentioning that. And then thereafter, as this court will see, both parties mention rape repeatedly. So there's nothing to suggest that Blaise unduly influenced KH here or even influenced her at all. To the extent he claims that Jacobson, that he should have been able to impeach Blaise about his first hearing, he made his point. He made sure that the board knew that she misstated the definition the first time. Through the way the questions evolved, he repeatedly made clear that she had misstated the definition the first time around. And the hearing officer reasonably exercised his discretion in keeping out her initial testimony because it wasn't relevant here. It was merely a collateral issue, and the hearing officer was focused on the issue of affirmative consent here. I would just like to get back to that one last time and just note that this is the precise situation that the Enough is Enough law was designed to protect against. The law wasn't needed to protect against forcible sexual assault. Rather, it was intended to prevent students from taking advantage of one another when they were not capable of consenting as a result of intoxication. And KH falls squarely within the statute's protections.
Thank you.
If I may pick up on my learned counsel's definition of substantial evidence. Accepting her definition of it would mean that this court, as a reviewing court, would have to find it rational and reasonable that the board's decision that despite her graphic and detailed description of geographical and temporal events over an 8-hour period, that she suffered from multiple bouts of blackouts and amnesia, but that only occurred at the times of the initiation of vaginal sexual intercourse, which coincidentally is the exact trigger that's necessary for the statute. And they'd also have to find that it's reasonable that despite these inconsistencies, that as the board says, she fell asleep or was unconscious. And again, this was only at those times. And as she says in her later impact statements, and she said in the initial impact statement, all of this came back to her after therapy. She doesn't tell us what the therapy is, but even assuming it was some sort of retrograde hypnosis therapy, which of course has come under attack for the possibility of suggestion to begin with, let's assume that that's not the case. Let's assume that there was regression hypnosis. Well, if we accept the board's conclusion that she was asleep or she was unconscious, I ask you to show me how it's rational that someone can now remember an incident that they weren't aware of to begin with. What I'm saying to this court is if you read everything she says, both her testimony and her subsequent commentary, the conclusion that she asks you to make, that she asks the board to make, does not flow, is disconnected from the statements she makes, because the Enough is Enough law talks about words and actions, which this court made clear, not words or actions. Words and actions, not feelings and supposition. And that's exactly what she tells the board. I felt that I didn't consent, regardless of what I did. And in terms of the due process arguments, I submit to you a reading of both the briefs and, of course, of the record makes it clear what we could hear and what we couldn't. The fact that it was easy to follow along with something she was reading was one thing. The fact that we couldn't do that with something we had never seen before or heard is a whole other thing. And beyond that, that's all I have to say, and I thank you for listening.
Thank you both. We'll take a recess.
All rise.